let's start with the summary judgment. But if and I guess we're doing summary judgment, Mr. McKenzie can stay in the courtroom for that if you like. Mr. Champagne, it's your motion, so you may make argument.
Judge, do you want a record on this?
No, we don't typically do a record unless
I would like a record on this.
Ms. Hayes, let's go ahead and do a
Okay.
record.
Judge, I would request that the YouTube feed be taken down, and here's why. First of all, yesterday, the Court of Appeals came out with a ruling in this case on Mr. Champagne's complaint that the YouTube feed was taken down in Judge Howell's case. And it specifically says that since this is not a criminal proceeding, he is not entitled to a Sixth Amendment right to a public hearing. Additionally, the open courts provision of the Texas Constitution does not apply to hearings. The open courts provision of the Texas Constitution is to allow the public to have access to the courts to redress injuries done to them, that anybody can file a case into the Texas court to address an injury. That's what the open courts provision is about. It's not about open proceedings, and a court can close a courtroom physically or virtually at any time. In fact, Travis County is one of the only courts that I have practiced in that is broadcasting on YouTube. The other surrounding counties don't. So the reason that I'm asking that this be taken down is because, first of all, this is our fourth hearing in this case since June. The last 3 hearings before Judge Howell, before Judge Seufer, and before you were all recorded in violation of the admonitions made to Mr. Champagne. Not only were they recorded after the admonitions and after he—
I'm going to object to that.
Excuse me. And
Speculation.
Mr. Champagne, this is argument. I'll give you a chance to respond.
All of those videos, all of those recordings are posted on YouTube. So it's not speculation. They are recorded. They've been disseminated to the public. With commentary and edited. So they are not the official transcription, and they are misleading, and they are in direct violation of the Travis County rule on this, the local rule, which I have cited, and I will pull up in just a minute, but there's the new local rules. Sorry, let me pull it up so that I can cite the actual rule. It is in the first amended Travis County Association.
Objection, attorney counsel is testifying.
Mr. Champagne, she is not testifying. She's pointing me to a local rule. Please, you will be given an opportunity to respond. Please don't object to her argument. Yes, Ms. Wyman, what do you want to point my attention to?
The first amended Travis County Associate Judge's procedures for remote hearings and in-person hearings as of June 17, 2020, is section 2D, and very specifically says in bold capital letters, no hearings shall be recorded. It's the same that each judge has admonished Mr. Champagne and everyone watching on YouTube at the beginning of every hearing in this case that has been recorded, and not only recorded, but uploaded to YouTube. So I am asking that the YouTube feed be taken down. Additionally, Mr. Champagne and his cohorts not only post them to YouTube, but with their commentary, smear me personally, the court system, the individual judges. Some of their statements are libelous, inflammatory, and quite honestly put my safety at
Objection,
risk.
hearsay.
Mr. Champagne, overruled. You're not objecting to, it's an argument, it's not evidence, right?
Quite honestly, it puts my safety at risk. And I don't think that lawyers or judges should have to put their safety at risk because of some public's interest in watching a suit affecting parent-child relationship. There is nothing in the Texas Constitution that says, or the US Constitution, that says that the public gets to watch family law cases. The Sixth Amendment.
Well, hold on, you're right, but we have open courtrooms.
Mhm.
Courthouse is open, and if we were in the courthouse, people can walk in and out of my courtroom. It is true, however, that I have the inherent authority to make sure that court procedures are followed, that if people are unruly in my courtroom, I can have the deputy remove them. If people refuse to not follow the court's instruction in the courtroom, I can have them removed, and that I can lock the courtroom and not let people in. All of that is true. So,
And that's what I'm getting at in terms of the same thing can happen remotely. And that's not violating anybody's constitutional rights. In fact, putting my safety at risk and allowing it to continue to be recorded and uploaded so that I am personally smeared on the internet puts my safety and my constitutional rights at risk. And so I'm asking that it be taken down. I am also asking that this court, who admonished Mr. Champagne and the last two judges who also admonished him not to record, and told him he would be in contempt for doing so, and yet he did it anyway, that they're actually—
Objection,
hold on,
speculation.
Ms. Wyman, stop. I'm going to let Mr. Champagne respond. The court is aware because the court has seen that the last hearing I had was recorded. I don't have any evidence that Mr. Champagne did that recording. So let me hear from Mr. Champagne.
If I could just point out why I believe it's at least in part Mr. Champagne, because on the July 14th hearing, Judge Howell shut down the YouTube feed at the break. And the second half of the hearing was not broadcast on YouTube. And he was very clear as to why he was not going to be broadcast on YouTube. Yet, the recording that's been uploaded to YouTube is the audio of the second half of that hearing. And the only persons who would have access to that would be Mr. Champagne, myself, Judge Howell, and my client. And I can assure you my client and I didn't record it. I don't believe Judge Howell did either. So the only person who could have recorded it is Mr. Champagne. Now, the other ones could have been recorded by anyone, but that for sure was had to be. So I do want there to be some, because like you said, if we were in the courtroom and someone were behaving badly or violating court's orders, or the bailiff could take him away. And here, I think they have the safety of this virtual world that they can break court rules and there's no sanctions. So I'm asking that that be addressed.
Mr. Champagne, let me hear from you. Mr. Champagne, are you frozen? Mr. Champagne, I need to hear from you. All right, he has logged off. Let's see if he logs back on in just a second. I'll let him back in. Mr. McKenzie, I'm going to ask Ms. Chambers, can you move Mr. McKenzie back in the waiting room until we need his testimony? Or in a breakout room? Thank you. And Ms. Chambers, can I also ask that you send an email to Mr. Champagne and let him know that I'm waiting for him to log back in?
Yes, I will.
Thank you. There he is. Thank you. Mr. Champagne, now is your chance to address Ms. Weinman's request that I discontinue the YouTube feed.
Yes, I just lost connection, so I didn't hear the past 2 minutes. So I don't know what Daryl Whiney has alleged. So
Okay, what she has, let me summarize it for you. What she has alleged is that although there have been admonitions at every hearing you've had, that the hearings have all been posted to the internet, that the first hearing in front of Judge Howell, after he discontinued the feed, there was an audio recording of it posted, because I commented that we don't know that you were the one who posted the hearings. And she responded that as Judge Howell had cut off the YouTube feed, the only people who could have had an audio recording, which is against the admonition of the court, that any audio recording be made, was someone who participated in the hearing, that being you, Ms. Weinman, or her client. And Ms. Weinman avers that she nor her client posted the audio recording. And therefore, and furthermore, that this is, she argues, and I agree with her, that I have the inherent ability to control my courtroom. And if we were in person in the courtroom and people were disobeying my orders, I could have them removed from the courtroom if people were not speaking or were recording in violation of my admonition. And therefore, she argues, because someone is violating the court's admonition and is posting all the hearings in your case, she has asked that I discontinue the YouTube feed. It is true that Ms. Weinman cites the associate judge's local rules that you are not to no recording of any hearing is to be made by anyone other than the court reporter. That is also an admonition I have given in before every hearing I've had, including the last one you were in front of me. And I have seen that the last hearing in which I gave that admonition, the hearing was recorded. And so Ms. Weinman is asking me to use my inherent power to control my courtroom to discontinue the YouTube feed. And you may respond to that.
yes, first of all, I'm going to ask that the court ignore Daryl Weinman's testimony. Her comments are not arguments, which are supposed to be based on evidence. She's not presented any evidence to that. I'd also like to note that there is a document from the Office of Court Administration, the Background and Legal Standards for the Public Right to Access Remote Hearings During the COVID-19 Pandemic. And it notes very specifically that these matters extend to family law cases as well. I can't speak to why people are reporting this hearing. I have a constitutional right. Section 13 of the Texas Constitution states that the court shall be open. And I'm requesting that the courts remain open so that this court be in alignment with the Texas Constitution. I don't know why people are doing this. I just know that it's happening, but I can't control other people.
Well,
And
all
to
right.
violate my constitutional rights is a violation of your oath of office, which is that you are to uphold the Constitution of both the United States and Texas. Your Honor, I just want to state, I don't have counsel. I'm just a regular guy. I'm just here. And really, I feel like they're trying to bully me, and bad things happen when things are not being watched. It's said that sunlight is the best disinfectant. And I just want to know that people are watching in case anything happens. The public has a right to serve as a check on the judiciary in case anything bad happens. And I want to make certain, not that I'm accusing you of doing anything bad, Judge Mauzy, but I want to make certain that I'm protected. Daryl Whiney has asserted that she's worried about her constitutional right to safety. I also have a constitutional right to safety. And what she is asking the court to do is to remove my constitutional right to safety so that she can have her rights protected. You can't assert your rights over another individual to simply do that.
Thank you. I do find that the open courts provision is designed to allow you to have access to the courts, that is to file lawsuits, and that we are trying to comply in letting the public be able to attend hearings. But just like in the regular courtroom, if people disobeyed my inherent authority to control my courtroom, I could have them removed. And I do find that based on that there has been an admonition given in every case in this trial that there are to be no recordings. And yet every hearing conducted in this matter, there is a hearing that is posted on the internet. So based on that, and based on my inherent authority to control the courtroom, especially given that this is a private family law matter, which doesn't have ramifications like some other sort of civil matter might have, I will ask Ms. Chambers